Hello friends and Namaskaram. Today I am going to discuss an important topic concerning your rights at law. Basically, the present class is concerning about your rights in case of any false departmental action against you. Friends, as we know that in India it is not very much typical to get a job. But when the journey is inter alia witnessed by such type of action in that scenario, the conclusions may be panic. It may be resulted in a minor penalty or a major penalty or sometime in termination or seizing of your services. So what to do? This is a basic problem of public servant. But in absence of solution, the inter alia have to face such type of proceeding. Friend, remember one thing. In case we are going to contest such type of proceeding in a humble manner, we cannot win. Because Darwin says, if you want to survive, be ready for war. And the primary principle of war is that you must be strategical in your approach rather than be aggressive. So the primary stage of strategy is that we must understand the existing legal position so that we could contest such proceedings in a very easy and effective manner. So to understand the same, we must maintain notes in our notebook. So write down the fundamental question what to do in departmental action. And apart from that, write down the additional question what will be the time limitation. Friends, concerning the time limitation, Honorable Rajasthan High Court had given the valuable judgment in favor of public servant recently. Judgment had been pronounced on 5th of Feb 2025 in a case titled as Sushila Devi versus State of Rajasthan. The concerned case number is 1269/2025. Judgment is pronounced by Honorable Rajasthan High Court. In that case, the concerned petitioner is a public servant. Inter alia, she was charge sheeted as per rule number 16 of Rajasthan Civil Services, Classification, Control and Appeal Rules 1958. Inter alia, she submitted reply promptly, but she inter alia raised two primary contention. Condition number 1, the proceedings are false, and apart from that, it had been initiated at the fag end of her career. And apart from that, the proceeding must be conducted in the speedy manner. Friends, every accused has a right to say that he or she is innocent. Every accused is a right to have the proper, fair and time-bound conclusions. So concerning same, Honorable Supreme Court in a case concerning departmental action had given the valuable guidelines. The concerned title is AIR 2016, Supreme Court, page 101. AIR means All India Reporter. In the said judgment, Honorable Supreme Court had propounded that it is a duty of employer to ensure that departmental action must be concluded within a period of reasonable time. And apart from that, fair and appropriate measure is to be taken to conclude the proceeding as soon as possible. And apart from that, if the concerned employee is under suspension, the directions become more imperative and required to be followed more effectively. To avoid any perjury or inconvenience or loss to the rights of the concerned charge official. So considering the same, the argument was done. So looking to the facts and circumstances, Honorable Rajasthan High Court submitted that the prayer is limited. The basic prayer of the concerned petitioner is that the proceeding is to be concluded within a period of reasonable time. So what is reasonable time? Concerning same, we internally observed the facts, we internally observed the reply of the case. The court submitted that the conduct of concerned petitioner is not that she is going to delay the proceeding, rather than she had submitted the reply promptly. But remember one thing, while submitting reply, you internally follow the principle of anxiety. Never. Always read the charge sheet or SCM. Make the proper reply, raise the probable defenses, and apart from that, if you are not able to get the copy in the proper manner, submit the objection at the earliest. In case you are not able to raise the objection at the earliest, you cannot raise the same subsequently. And apart from that, it is your legal right to get all the documents, all the witnesses' statement in support of concerned prosecution so that we could defend the case in a proper way. Because on the basis of their document, they will prepare prosecution brief, but on the basis of your stand, you are required to prepare the defense brief. Regarding the same and to make the proper cross-examination, the documents are sine qua non. And apart from that, you are having the right to have the assistance or proper aid of a lawyer or defense assistant. This is not the mere formality. This is your fundamental right. And apart from that, the principle of natural justice requires that reasonable opportunity of defense is to be given to you. If these opportunities are not given, in that scenario, you may raise the point of prejudice. Apart from that, court specified that although the reasonable time is not defined or not specified, but looking into the fact circumstances of each and every case, the concerned authority shall make endeavor means efforts, to conclude the departmental action within a period of 6 months. So I think that this period appears to be reasonable, because if the proceedings are allowed to be continued for the infinite time, in that scenario your rights will be affected. And apart from that, if in the reasonable time the proceedings are not concluded, in that scenario the consent time can be extended, but for the same the reasons are required to be given. So the court specified that the consent delays should be avoided to protect the rights of the concerned public servant. And apart from that, the present case is the specific case wherein the proceeding had been initiated at the fag end of career, because proceeding had been initiated on 4th of September 2024, and in March 2025 she is about to be retired. So in that scenario, the court had given the time of 4 weeks from date of receipt of order, but this is not the universal formula. The universal formula is that the authority shall make endeavor to conclude the proceeding within a period of 6 months, and if it is not possible, extension is required. In that scenario, the specific reasons must be on record. If they are not there, it means the authority is going to play with the right and liberty of the concerned charged official. Remember one thing, in departmental action we are not accused, we are charged official, and the inquiry officer is bound to follow the guidelines as well. So the said judgment inter alia provided the 5 important guidelines. Number 1, in departmental action you are having the right to have the conclusion within a reasonable time, that is 6 months. Number 2, you are having the right to get documents in a proper and legible manner, and apart from that, the concerned authority shall endeavor to conclude the proceeding as soon as possible, and if you are placed under suspension, in that scenario the direction becomes more imperative. And apart from that, the proceeding cannot be without any material or specification, strong ground should be there. And apart from that, if you inter alia submit your reply within a time, and apart from that makes an objection and they fail to do so, then you may avail the remedy before Honorable High Court under civil writs. So these are the important guidelines. So we have to follow and we have to understand the same, so that we could protect our rights in near future and even at present. So see you in the next topic and in next class. Till then, Jai Hind, Jai Bharat.